Hello and welcome to Unacademy. Welcome to Polity Project 2.0. This is lecture number 4. The Representation of the People Act 1951. An important law enacted by the Parliament, and we will discuss this law in great detail, strictly according to the requirements of this examination. Nothing more, nothing less. But listen to me carefully. There is another law, the Representation of the People Act 1950. How is that law different from the 1951 law? That I will explain towards the end of this lecture. Let's get started and let's look at the Representation of the People Act 1951. If someone is going to ask you, can you name a law which governs the conduct of elections in this country, the entire conduct of elections in this country, you should reply, it is the Representation of the People Act 1951. Election notification, election campaign, returning officers, EVMs, VVPAT, qualifications, disqualifications, corrupt practices, undue influence, election petitions, all the conduct of election governing in India is because of this law, Representation of the People Act 1951. And let's discuss all the provisions of this law in great detail together with the observations and the verdicts of the Honorable Supreme Court. First up, the most important judgment, Union of India v. Association for Democratic Reforms. The year was 2002. ADR, which is a non-governmental organization which deals with electoral reforms in India, which works in the field of electoral reforms in India, approached the Supreme Court and asked the court, "My lord, do we have a freedom of speech and expression under Article 19, Clause 1, Clause A of the Constitution?" Supreme Court said, yes. You can say whatever you want to say, express whatever you want to express. If we can say whatever we want to express, can we also ask questions? The court asked, yes, but for whom? ADR said, we want to ask questions to the candidates who are contesting elections. But why? If we know about these candidates, it is only then we can make an informed choice. There are so many candidates contesting the election. Unless and until we have information about these candidates, we will not be in a position to decide who to vote for and who not to vote for. So we need to know the antecedents of the candidates contesting elections, and that is how we will be in a position to make an informed choice. If you're still not able to understand, let me give you an example. You want to prepare for the civil services examination and you want to enroll in a coaching institute. Let's assume you want to enroll in an online coaching institute, but there are umpteen online coaching institutes. Which one to choose for your preparation? You need information about all these coaching institutes, and that is how you will be in a position to decide which coaching institute to join to prepare for this examination. For example, if I tell you that right now, if you enroll with us for your UPSC preparation, we are going to give you 60% off on UPSC subscription. And our UPSC subscription would be available at 17,999. This is the cost or the fee that you need to compare with other coaching institutes. Maybe fee can be a determining factor for you to decide which coaching institute to join. Now let's assume that no coaching institute tells you who is going to teach you polity, economics, geography. Is there a coaching institute which is run by one individual, or do we have teachers for every single subject for this examination? That's how you will be in a position to make an informed choice. And that's precisely what is the purpose. If I tell you that for your 12 months, 18 months, 24 months, 36 months, this is the price that you need to pay to subscribe to our courses. We are giving you full information. Basis this information, then you can decide whether you need to join Unacademy or any other academy. And that's exactly what Supreme Court said. Supreme Court said, right to make an informed choice is a fundamental right under Article 19(1)(a) of the Constitution. That is why, since this judgment, you would notice whenever a candidate is contesting election, in the election affidavit, he or she reveals certain pieces of information. What is your educational qualification? What is the amount of assets in your name and in the name of your spouse? What are the criminal cases pending against you? Once this information is known to the public, known to the voters, voters can then decide and make an informed choice as to which candidate to vote for. That is the most important judgment of the Supreme Court on the Representation of the People Act 1951. That's number one. Number two, if we know the Constitution tells us that in order to become the member of the Lok Sabha, you should be the citizen of India, you must have completed 25 years of age. In order to become the member of the Rajya Sabha, you should be the citizen of India and you must have completed 30 years of age. Ditto for Legislative Assembly and Legislative Council. But are these the only qualifications in order to contest elections? No. Constitution says further qualifications can be prescribed by Parliament, by law. That means additional qualifications can be prescribed. And who will prescribe these qualifications? Parliament. How? By enacting a law. Which is that law? Representation of the People Act 1951. For example, if you want to contest elections to Rajya Sabha, you should be the citizen of India, you must have completed 30 years of age, and you should be a registered voter in any parliamentary constituency in this country. Till the year 2003, the requirement was that if you want to contest elections to Rajya Sabha from Karnataka, you should be the registered voter of Karnataka. If you want to contest Rajya Sabha elections from Uttar Pradesh, you should be the registered voter of Uttar Pradesh. But in the year 2003, Representation of the People Act 1951 was amended. Amended in the sense, two important changes were made. Change number one, this requirement that you should be the registered voter of that state in order to contest elections to Rajya Sabha, this was done away with. That means now, you can contest elections to Rajya Sabha from any state in India if you are a registered voter in any parliamentary constituency of this country. That is how Dr. Manmohan Singh, despite the fact that he was a registered voter in Delhi, but he was representing the state of Assam in the Rajya Sabha for close to 10 years or more than that as well. Which means change number one, because of the amendment to this law in 2003, if you are a registered voter in any parliamentary constituency in this country, you are a registered voter in Delhi, you can contest Rajya Sabha elections from Tamil Nadu, from Karnataka, from Odisha, from Punjab, so on and so forth. Change number two. Previously, the elections to Rajya Sabha would be conducted through closed ballot, secret ballot as we call it. But the change made was, now the election will be conducted through open ballot. Which means if I'm a voter and I have to vote in the Rajya Sabha elections, I have to show my vote to my party's representative so that he or she can get to know whether I'm voting in favor of the party's nominee or I'm cross-voting. Both these changes, which means a shift from secret ballot to open ballot and changing the requirement of a domicile, these two changes were challenged in the Supreme Court by the journalist Kuldeep Nayyar. And finally, the judgment was given by the court in 2006. The Supreme Court said in 2006 that if we want to remove the requirement of residence that you should be the registered voter of that state in order to contest Rajya Sabha elections, that does not mean we are violating federalism, which is part of the basic structure of the Constitution. Why? Because right to contest elections is a statutory right. It's not a constitutional right. It's not a fundamental right. If it is a statutory right, which means the right provided by the law can be changed by the Parliament. Number one. Number two, the Parliament in its wisdom has decided to remove or replace secret ballot with open ballot. This is to ensure that there is no cross-voting. This is to ensure that you are voting for the candidate which is set up by your political party. Because let's be fair, in India, we are a democracy, and democracy thanks to political parties. You and me, majority of us, we vote for a candidate not because of who he or she is, but because of the political party that they represent. So our political system is based in such a manner that we give primacy to political parties rather than individual candidates. And if the party has given you the ticket to contest the elections, and you have won the elections, and now because of that you are the member of the Legislative Assembly, now you have the right to vote to elect a member to the Rajya Sabha, you have to toe the party line. You have to vote in favor of the nominee which is set up by the political party to ensure that there is no cross-voting. That is why we have shifted from secret ballot to open ballot. That's another important judgment. Now listen to me carefully. Constitution says a member of the legislature, whether it is Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, you can also be disqualified. On what grounds? If there is a change in the nature of citizenship. Because in order to contest elections, you should be the citizen of India. What if after the election, after you have won the election, you renounce your citizenship and you become the citizen of South Africa? You will be disqualified. Change in the nature of citizenship will make you liable for disqualification. If you have been adjudged insolvent, bankrupt, disqualified. If you have been found guilty of holding office of profit, disqualified. So change in the nature of citizenship, adjudged insolvent, mental unsoundness. You were mentally sound when we voted for you and we sent you to represent us in the legislature, but after that you turned insane. We may have sympathy with you, but we cannot entrust you with the responsibility of making laws for the people of this country. You will be disqualified. But can there be other grounds for disqualification apart from these grounds? Yes. Who will decide that? Parliament. How? By enacting a law. Which is that law? Representation of the People Act 1951. And now listen to me carefully. There are three important things that you have to keep in mind. You may have heard, you may have read that if there is a legislator who has been sentenced to 2 or more years in jail, only then you are disqualified from that legislative house. This is incorrect understanding. You have to keep in mind something. If you are found guilty as a legislator, you are a legislator, whether a member of Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, but as a legislator, listen to me carefully, if you have been found guilty of promoting enmity amongst different sections of the society on the grounds of religion, race, place of birth, or if you have been convicted for bribery, or you have been convicted under untouchability laws, or you have been convicted under the Prevention of the Corruption Act or Prevention of Terrorism Act 2002, although this law has now been repealed. But be that as it may, if you have been found guilty of any of these offences under Section 8, Clause 1 of the Representation of the People Act, even if a fine is imposed, forget about conviction, imprisonment, even if a fine is imposed, you are disqualified. Even if a fine is imposed, you are disqualified. And then you are further disqualified for a period of 6 years. Which means if I am a legislator and I am found guilty of committing an offence under Section 8, Clause 1 of the Representation of the People Act, which means any of these offences, even if I am not sentenced to jail, even if I am not subjected to imprisonment, but even if a fine has been imposed on me, I will be disqualified. And then from the date fine was imposed, for the next 6 years, I cannot contest elections. I am disqualified from contesting the elections. Which means if Representation of the People Act talk about qualification of the members, it also talks about disqualification as well. Now listen to me carefully. Disqualification under Section 8, Clause 2. Now in this case, if I'm a legislator, and I'm found guilty of violating a law which is meant to prevent hoarding or profiteering, or I am resorting to adulteration of food, or I am being found guilty of violating the Dowry Prohibition Act. Here now, if I am sentenced to 6 months or more, which means if I am a legislator, I am found guilty of these offences or any of these offences, but I have been sent to imprisonment for less than 6 months, I will not be disqualified. But if I am sentenced to imprisonment for 6 months or more, I will be disqualified. And once I am released from the prison for a further period of 6 years, I will not be able to contest elections because I will be barred. I will be disqualified from contesting the election. Section 8 clause 1, even if a fine is imposed, disqualified, and disqualified for a further period of 6 years. Section 8 clause 2, only if you have been sentenced to imprisonment of 6 or more months, only then you are disqualified, and then once you are released for a further period of 6 years, you cannot contest elections, you are disqualified. Now, any of the offences which are neither mentioned under Section 8 clause 1 nor Section 8 clause 2, which means except these, whichever other offense you are found guilty of. Sir, for example, criminal defamation. In this case, if you are sentenced to 2 or more years in jail, that means minimum 2 years in jail, you will be disqualified. That means once there is an individual legislator who has been found guilty of any other offense other than those mentioned in Section 1 and Section 2, you will be disqualified only if you are sentenced to 2 or more years in jail. And that is how Shri Rahul Gandhi, the then member of the Lok Sabha, who was found guilty of criminal defamation by a court in Gujarat and sentenced to 2 years in jail, he was disqualified. The next day by the Lok Sabha Secretariat issued a notification and said, Shri Rahul Gandhi, you are disqualified. But what is the option available for these disqualified legislators? They can approach the High Court. And if the High Court suspends the sentence, which means you can be reinstated as the member of the legislature. If High Court does not allow, you have to move the Supreme Court. And if the Supreme Court sets aside the conviction and decides to hear the case again, you can also then retain your seat as the member of that legislature. But now listen to me carefully, very, very carefully. What if I am a common man, Aam Aadmi, not belonging to Aam Aadmi party, I am a genuine Aam Aadmi. And if I have been found guilty of any offense under Section 8 Clause 1, for example, I am promoting enmity on the grounds of religion. Let's assume I have not been sentenced to jail, only a fine has been imposed. Or let's assume I have been sentenced to a jail term. Once I am released, can I contest elections? No. Which means for a further period of 6 years after my release, I cannot contest election. Similarly, for those who have been found guilty under Section 8 Clause 2, similarly for those who have been found guilty under Section 8 Clause 3, which means if Shri Rahul Gandhi was convicted and his conviction was not set aside by the higher courts, he would have to serve 2 years in jail. And once you are out of the jail, once you have completed your jail sentence, then for a further period of 6 years, you cannot contest elections. But what if I am a common man, an Aam Aadmi? Can I contest elections? No, because I have to wait for 6 years, because that is the period of disqualification. But what if I am already a legislator? For that, there used to be Section 8 Clause 4 of the Representation of the People Act 1951, under which if I'm a legislator and found guilty of Section 8 Clause 1, 8 Clause 2, 8 Clause 3, and I was sentenced to 2 years in jail or 5 years in jail or a fine has been imposed, I was not immediately disqualified. I was given 3 months. That since you are a legislator, we will give you 3 months, you appeal before a higher court. Even if the High Court finds you guilty, even then you are not disqualified because you have 3 months to appeal before a higher court, which is the Supreme Court. And only if the Supreme Court decides that yes, you are guilty, then you are disqualified. Matter went to the court. Lily Thomas v. Union of India. Lily Thomas asked the court, "My lord, this provision violates Article 14 of the Constitution." The court asked, "How?" Miss Lily Thomas said, Article 14 talks about right against arbitrariness. The laws cannot be arbitrary. The court asked, "How is this law arbitrary?" Lily Thomas replied that if there is a legislator and there is an Aam Aadmi, if this Aam Aadmi has been found guilty of any of the offences mentioned under Representation of the People Act, but now he has completed that sentence, can he contest elections? No, because you are further disqualified for 6 years. But what if there is a sitting legislator? A sitting legislator has been found guilty, you are not disqualified. Instead, you are given a 3 months window to appeal. Why is this 3-month window not given to an Aam Aadmi? Which means you are creating an illogical, arbitrary distinction between man and a man in political affair. And any arbitrary distinction between man and a man in a political affair violates political justice, which is one of the objectives of the Constitution mentioned in the preamble. And this objective is part of the basic structure. Supreme Court said, "You are absolutely right." Now, the moment a legislator is convicted, whether under Section 8 Clause 1, 8 Clause 2, 8 Clause 3, there will be immediate conviction. That means you will not be provided with a 3-month window. Yes, you can appeal, but previously what was happening? You were not disqualified because you had to appeal within 3 months. Now, you will be disqualified. And then you can approach the court. And then if the court decides that yes, your arguments are sound, we can suspend your sentence, we can reinstate you as a legislator. Only then, on the orders of the court, will you be reinstated as the legislator. Otherwise, no. That is thanks to Lily Thomas v. Union of India 2013. But does it mean immediate conviction or automatic conviction? Let me know in the comment section, because there is a difference between immediate conviction and automatic conviction. And I will explain it towards the end. Now listen to me carefully. There is something called undue influence. For example, you have property. You have townhouses, villas, luxury cars. And I want you to give me the ownership of your entire property. Right? I'm trying to convince you. And through my convincing ability, you are transferring your entire property in my name. Right? But this is something that you're doing on your own. I'm trying to convince you. I'm giving you strong reasons why you should transfer your property in my name. But what if I try and use a revolver and point it at your head and now tell you that whatever property you have should be transferred in my name? This is called undue influence. Similarly, in elections, can I ask the voters that you should vote for me because I will do this, I'm promising this, I will change your lives? Yes. But what if I bribe the voter? That is undue influence. And if I do that, I will be disqualified. Can I ask people that you should vote for me because I am a Hindu? Or you should vote for me because you are a Muslim? Asking for votes in the name of religion or language or caste, it's a corrupt practice. Amounts to undue influence on the voters. Very important case. Ram Dayal v. Santlal, 1959. Ram Dayal is contesting election. And there is a religious leader who is asking the people to vote for this candidate, to vote for a particular candidate. Can you do that? Can you tell your followers, if I'm a religious leader, can you tell your followers that you should vote for this candidate? Is it allowed under the Representation of the People Act? Matter went to the court. The court said there is a difference. As a religious leader, can I tell my followers that you should vote for this candidate? Yes. For example, I think in 2006, the Shahi Imam of the Jama Masjid in Delhi met Shrimati Sonia Gandhi, and immediately after that meeting, he announced it to the followers that you should vote for Shrimati Sonia Gandhi in the Rai Bareli constituency. So can a religious leader tell his followers that you should vote for a particular candidate? Yes. But there is a difference. If you tell your followers that you should vote for her or him, and if you don't do that, there will be wrath of God. God will be extremely angry. And you will face consequences in the life hereafter. You will rot in the hell. This is your religious duty that you have to vote for her and no one else. This amounts to undue influence. And since undue influence was exerted in this case, when the religious leader of the Namdari sect urged his followers that you should vote for this candidate, otherwise there will be wrath of God, otherwise you will face consequences, because it's a sin not to vote for him. This is undue influence, and as such, you will be disqualified. That's number one. Something else. Listen to me carefully. I told you that right to know is a fundamental right. As a voter, I need to know the educational qualifications of a candidate, the number of criminal cases pending against him, the amount of assets in his name and in the name of his spouse, so that I can make an informed choice. What if you are not disclosing your income? You're not disclosing your income. Will that amount to undue influence? Lok Prahari v. Union of India 2018 Supreme Court said yes. If you're not disclosing your assets, if you're not disclosing the sources of income, that amounts to undue influence. Why? Because voters have the fundamental right to know the financial background of the candidates. I need to know from where are you getting the money? What is your source of income? So that I can find out whether you are a person of integrity or not. In the last election, the amount of assets in your name was X. In the current election, the assets have increased to 5X. There is something fishy about you. Maybe you're not a person of integrity. Tell me the source of your income so that I can decide whether I want to vote for you or not. If you do not disclose your assets and your sources of income, that amounts to undue influence and you will be disqualified, according to Lok Prahari v. Union of India 2018. Now comes the important judgment, the latest judgment of 2024. Now listen to me carefully. I need to disclose assets and the sources of income. Listen to me carefully. I am the owner of luxury cars, luxury motorcycles, expensive ones. If I don't disclose them, I'm hiding something. I'm not the man of integrity. I should be disqualified because I have to tell my voters about my assets, inform them so that they can make an informed choice. But is it necessary to include all the details, or can you skip some? Kariko Kri v. Nunne Tayang 2024. Kariko Kri won the election. It was challenged on the grounds that you have hidden some details. Which details? Kinetic Zing Scooty, Maruti Omni Van, TVS Star City motorcycle. What does that mean? Listen to me carefully. You have to reveal the amount of assets in your name and in the name of your spouse as well. Kinetic Zing Scooty, Maruti Omni Van was in the name of his wife, but she had already sold it. But when you sell your vehicle, it will take time for the ownership to change, for the RC to change. That RC had not changed at the time when he filed his nomination papers. So should I include that or exclude? I'm filing my nomination papers now, but the two vehicles in the name of my spouse, she has sold them. But the ownership has not reflected online yet. The ownership has not changed yet, but it will change. Why should I include this in my election affidavit? And there was a TVS Star City motorcycle, but it was in the name of my son, my second son. The opponent who lost this election approached the court and said he should be disqualified because he has not revealed this information. Supreme Court said no. Why? The returning officer can reject the nomination papers only if there are substantial defects in your nomination papers. If you have hidden some pieces of information which are of substantial value, if you are hiding, basis this judgment we can say, if you are hiding that you are owning a Porsche vehicle or a BMW or a Mercedes, this can be viewed as substantial and you will be disqualified, or your nomination papers can be rejected. But if you're hiding that I own a Maruti Omni van which belongs to my wife and the wife has sold it to somebody and it will take some time for the ownership to change, this does not amount to undue influence, because only if you suppress substantial information that will make you liable for disqualification. That's something that you have to keep in mind. But now listen to me carefully. Mr. Manohar Joshi, a member of the Shiv Sena, then led by Bala Sahab Thackeray. Mr. Manohar Joshi later became the Chief Minister of the state of Maharashtra. In his election campaign, he gave a speech and said, "Vote for us and we will make Maharashtra the first Hindu state of India." Mehraj went to the court. Why? He should be disqualified. Can you ask for votes in the name of religion? In the name of caste? You can't do that. Because if you do that, that amounts to undue influence, corrupt practice within the meaning of Representation of the People Act. Matter went to the court. Justice J.S. Verma is the Chief Justice of India. And Justice J.S. Verma said, Hindutva is not a religion. Hindutva is a way of life of the people who are living in the subcontinent. Because there are some people who say, call me Hindu. That does not mean you are identifying yourself with a religion. You are identifying yourself with a geographical limit. All those who inhabit this area, which is beyond the river Sindhu or river Hindu, they were called Hindus. Because the Persians could not spell S. So that is why they called all these people as Hindus. So it's a geographical term rather than a religious term. So saying Hindutva or Maharashtra will be the first state, the first Hindu state, this does not amount to corrupt practice. Why? Because at best it's an expression of hope. The court said the first Hindu state will be established. It is not an appeal for votes on the ground of religion. The court interpreted that this is only an expression of hope. We are not appealing, or he is not appealing in the name of religion. He is not asking the Hindu followers to vote for him. He is only asking for a Hindu state. Hindutva as a term is a geographical concept. It's a way of life. It does not amount to religion. And since it does not amount to religion, asking for votes in the name of Hindutva is allowed. Something else. Abhiram Singh, we CD Kamachan 2017. Now listen to me carefully. 7-judge bench of the Supreme Court was set up just to understand one issue with a pronoun, his. Pronoun. What is the case? You cannot seek votes. And if you are seeking votes in the name of his religion, his caste, his language, it's a corrupt practice. But who is his? As candidate or a voter? What is the interpretation of this law? Is the law saying if you are asking for votes in the name of his religion, his language, his caste, it's a corrupt practice? Or is it also his religion, his language, his caste? That means you as an electorate. 7-judge bench of the Supreme Court had to decide. And majority said, by the majority of 4:3, that this pronoun his means candidate as well as the electorate. So neither you can ask for votes in the name of the candidate's religion, language or caste, nor in the name of the electorate's voters, candidate, religion, caste or language. It was thought that in 2017, the Supreme Court will revisit this Hindutva judgment given by Justice J.S. Verma in 1995, but the court in 2017 did not revisit. So this judgment stands even today. Hindutva is not a religion. Hindutva is a way of life, which means asking for votes in the name of Hindutva may not be a corrupt practice. As such, you will not be disqualified. Another important case, Subramaniam Balaji v. State of Tamil Nadu 2013. This was an interesting case. Interesting case in the sense the Supreme Court was also confused, gave two contrasting views. Do these freebies shake the root and cause of free and fair elections? And free and fair election is part of the basic structure of the Constitution. Freebies in the sense, particularly in Tamil Nadu then, and now it has become the practice throughout the country. Just before the election, you announce a scheme targeting women, whether it is Ladli Behan or so many different schemes targeting women. 10,000 rupees will be deposited into your bank account. Do these freebies amount to bribing the voters and as such undue influence and as such violative of the free and fair elections? In Tamil Nadu, the political parties would compete with each other, the Dravidian political parties, the DMK, the AIADMK. If you vote for us, we will give you juicer, mixer, grinder. Vote for us, we will give you a buffalo. Vote for us, we will give you a gold coin. Vote for us, we will give you VCR. Vote for us, we will give you color television sets. Matter went to the court. My lord, this amounts to undue influence, bribing the voters. Now, when I say the court gave conflicting views, what do I mean by that? Court said, number one, freebies. What Mr. Modi, the Prime Minister, says, Revdi culture. Freebies shake the root and cause of the free and fair elections. Who said? The Supreme Court. In the same judgment, Supreme Court says, but freebies don't violate free and fair elections. Announcing something in your election manifesto does not amount to corrupt practice. Political parties in Tamil Nadu were asked, come here. Why are you doing this? Why are you giving freebies? Color television sets. What is the purpose? What is the utility? The political party said, we give color television sets. This is primarily targeted at women. Because these women, they take care of household chores early in the morning, keeping breakfast ready, their daughters and sons ready for the school, their husbands, tiffin, so on and so forth. And then she is indulging herself in these household chores. And then in the afternoon, she needs time to relax. Turns on the color television set. There is a free cable network provided. She can watch any program to satisfy herself as means of entertainment. That is why we provide color television set. This is not freebie. This is social justice targeted at women. And by watching these color television sets, you can also watch current affairs programs. And through these current affairs programs, through the news articles, through the news bulletins, we can keep our electorate informed of the decisions that we take as a government. Maybe by giving color television sets, promising it in the election manifesto, we are primarily telling them that once we give you the color television sets, you can attend the lectures on Unacademy IAS English and listen to the political developments taking place so that you can be informed about your rights, your duties, liabilities, so on and so forth. Supreme Court said, we made Direct Election Commission of India. Election Commission of India, come here. Get in touch with political parties and see if you can make guidelines. Election Commission asked all the political parties to come and then told these political parties that tomorrow, if you're promising something, please also tell the voters from where are you going to generate funds to implement these freebies, to implement these election promises that you have made in the election manifesto. But political parties have not implemented. And currently, this matter, whether freebies shake the root and cause of the free and fair election, this matter is being heard, reviewed by a 3-judge bench of the Supreme Court. So now a 3-judge bench of the Supreme Court will tell us whether freebies are constitutionally allowed, or do they also amount to undue influence on the minds of the voters, and as such a corrupt practice within the meaning of Representation of the People Act 1951. What is the status of right to vote? If you have been enrolled in the electoral roll, you have the right to vote. And this is where I need to tell you Representation of the People Act 1950, because I promised you at the start that I'll tell you the difference between Representation of the People Act 1950 and 1951 towards the end. Constitution tells us that the strength, or the current strength, for example, of the Rajya Sabha is 245. Maximum it is 250. But from UP, how many MPs are there in Rajya Sabha? 32. Where is it mentioned? Schedule 4 of the Constitution. From Tamil Nadu, how many MPs are there in Rajya Sabha? 19. Where is it mentioned? Schedule 4 of the Constitution. From Andhra Pradesh, how many MPs are there in the Rajya Sabha? 11. How many MPs are there in the Rajya Sabha from Telangana? 7. Where is it mentioned? Representation of the People Act 1950. Where is it mentioned? Schedule 4 of the Constitution. But Lok Sabha has 543 MPs. 80 are from UP. Where is it mentioned? Not the Constitution, but Representation of the People Act 1950. From Bihar, how many MPs are there in Lok Sabha? Where is it mentioned? Representation of the People Act 1950. What is the strength of the Legislative Assembly of Sikkim, of Jammu and Kashmir, of Karnataka? Where is it mentioned? Representation of the People Act 1950. What is the strength of the Legislative Council of Andhra Pradesh, Telangana, Maharashtra, Bihar, UP, Karnataka? These are the states where we have Legislative Council. Where is it mentioned? Representation of the People Act 1950. So Representation of the People Act 1950 talks about allocation of seats for a state in Lok Sabha, in Legislative Assembly, in Legislative Council. Because for Rajya Sabha, it is already mentioned in Schedule 4 of the Constitution. For others, it is mentioned in the Representation of the People Act. Delimitation is a hot issue. Whether delimitation should be conducted or not conducted. Delimitation, once it is conducted, Delimitation Commission will conduct this, or Election Commission of India will conduct this, then the order will be issued under Representation of the People Act 1950. Right now, SIR, Special Intensive Revision, is going on. UP, Tamil Nadu, previously in states such as Bihar. Revising preparation. Who are the people involved in the preparation of electoral rolls? That is mentioned where? In the Representation of the People Act 1950. Qualification of a voter. Those who can be added to these electoral rolls. Where is it mentioned? Representation of the People Act 1950. Qualification of a candidate contesting election. Disqualification of a legislator, mentioned in Representation of the People Act 1951. But qualification of a voter, preparation of electoral rolls, seats assigned to different states in Lok Sabha, Legislative Assembly, Legislative Council, officers involved in the preparation of electoral rolls, delimitation of the constituencies, all that is mentioned under Representation of the People Act 1950. For everything else, the entire conduct of elections, we have RPA 1951. Now listen to me carefully and you tell me the answer. A legislator can be disqualified on the basis of the provisions mentioned in the Constitution, on the basis of the Representation of the People Act 1951 as well. Can a voter also be disqualified from voting? Or can only a candidate be disqualified from contesting the election? Or for holding this post of the legislator? Even a voter can be disqualified. Once Balasaheb Thackeray was disqualified as a voter. You can't vote in the elections because you have promoted enmity amongst different sections of the society on the grounds of religion. So even a voter can be disqualified. Representation of the People Act 1951 says you can only vote once in your constituency. You cannot vote in more than one constituency. And even in your constituency, you can vote only once. Now imagine, I have the right to vote in this constituency, in this polling booth. What if I am voting in this constituency as well, in two other constituencies as well? Will my vote in my constituency be valid and in other constituencies be invalid? No, my vote in all these constituencies will be invalid. I am voting more than once in the same constituency. All these votes will be invalid. None of your vote will be valid. Even if one was, you were eligible to cast your vote once, but even that is invalid because you have violated the provisions of Representation of the People Act 1951. But what is right to vote? Is it a constitutional right? Is it a statutory right? Is it a fundamental right? N.P. Ponuswamy, 1952, Supreme Court said right to vote is a statutory right. It's not provided by the Constitution, it is provided by the Representation of the People Act 1951. Jyoti Basu, 1982, Supreme Court said right to vote is a statutory right. PUCL case 2003, Supreme Court said if it is not a fundamental right, but certainly it is a constitutional right provided under Article 326 of the Constitution. Kuldeep Nair case, in which we discussed it previously, two things were changed: secret ballot, open ballot. And you can be a registered voter in any parliamentary constituency of this country in order to contest Rajya Sabha election. In this case, a 5-judge bench of the Supreme Court, because it was a constitution bench, Supreme Court said right to vote is a statutory right. But a few years later, in Rajbala case, Supreme Court said, a 2-judge bench of the Supreme Court said, right to vote is a constitutional right provided under Article 326. But this is where we come across a concept called judicial discipline. Whose judgment will prevail? A judgment given by a wider bench, larger bench, 5-judge bench, or a judgment given by 2 judges, 3 judges bench? Judicial discipline tells us that the judgment given by a larger bench prevails over the judgment given by the smaller benches. So if Kuldeep Nair case was heard by a constitution bench, this judgment will prevail over a 2-judge bench decision given later. So please keep in mind, if in 2006 Supreme Court said right to vote is a statutory right, and later in 2015 Supreme Court said right to vote is a constitutional right, does judicial discipline mean that judgment which was given later will prevail over the earlier judgment? No. Earlier, later doesn't matter. What matters is what was the strength of the Supreme Court bench which gave the judgment. Judgment given by 5 judges bench will prevail over the judgment given by 2 judges bench. And in fact, in Anu Baranwal case 2023, where Supreme Court said from now onwards, if you have to appoint the Chief Election Commissioner, if you have to appoint the election commissioners, for that the President will have to consult a body which will comprise of Prime Minister, Leader of the Opposition in Lok Sabha, and the Chief Justice of India. In this judgment also, Supreme Court said, right to vote is a statutory right, which means it is provided by the law. Which is that law? Representation of the People Act 1951, which means the current status is right to vote is a statutory right. I want to vote in the Indian elections, but I'm not. Why? Because when I look at the candidates set up by political parties, I see that most of them are rapists, corrupts with strong, severe criminal charges. What do? I disengage from the system. I don't vote. How should we enhance the democratic participation? How do we ensure that people participate in the festival of Indian democracy, which is elections? We need to engage with the citizens. And how do we engage? Give them another option, NOTA. So if there are the candidates contesting the election, last option you should give NOTA, none of the above. So that even if I am not satisfied with any of the candidates set up by the political parties, I can still engage with my democracy by voting in favor of NOTA. But even if NOTA gets the highest number of votes, the candidate who gets the second highest number of votes will be declared as a winner. Although this matter is now before the court. Previously, it was before the court. The court was asked, my lord, said, what? If NOTA gets the highest number of votes, the next candidate who has the second highest number of votes is declared as the winner. We should have a fresh election in this constituency. Supreme Court said, no, elections are a costly affair. If we keep on organizing elections after elections, it's going to be a drain on exchequer. It's going to misuse the funds available with the public. But now Supreme Court is hearing this case again. If the votes in favor of NOTA are the highest, will the election in that constituency be conducted and held again? That's for the court to decide. As of now, even if NOTA gets the highest number of votes, the candidate who gets the second highest number of votes is the representative of your constituency. Dr. Subramaniam Swamy, V. Election Commission of India, 2013. EVMs. EVMs were used for the first time in 1984 in Parur Assembly constituency in Kerala. Matter went to the court. Supreme Court said this election is null and void. Why? Because the Representation of the People Act 1951 explicitly talks about election should be conducted through ballot papers. And if you are conducting elections through EVMs, you are violating the law, and as such, this election is null and void. It was only in the late 1980s, in 1987, that Representation of the People Act was amended to provide for elections through EVMs. And since then, we have been using EVMs. If you want a precise date, it was 2004 onwards when we are using only EVMs, because prior to that, we were using a mix of EVMs and ballot papers. But EVMs have been declared unconstitutional in Germany. Netherlands, France, United Kingdom spent millions and millions of pounds and their currency to create an electronic voting machine, manufacture an electronic voting machine, but they junked the idea. Is our EVM, are our electronic voting machines so foolproof, tamper-proof that we rely on EVMs? Yes, they cannot be hacked. But there is one problem, or there used to be one problem, and the problem was lack of transparency. If I have pressed the button on the electronic voting machine, vote has been registered, but how do I satisfy myself that whether this vote has been registered in favor of the candidate of my choice or this vote has been registered in favor of someone else? I need to see the proof. And this is where, basis this petition by Dr. Subramaniam Swamy, the Supreme Court provided for VVPAT, Voter Verifiable Paper Audit Trail. Not trial, trail. So as soon as I press the button on the electronic voting machine, information gets displayed for 7 seconds. What is the serial number of my vote? What is the name of the candidate against whom my vote has been registered? What is the symbol of that political party or the candidate? I get to see this information for 7 seconds. After that, the slip gets cut and gets deposited into the ballot box. That's enhancing transparency, and that is thanks to Supreme Court. But listen to me carefully. What if in an election, and this is something provided by the Representation of the People Act, what if in the election there are 4 or 5 candidates, but at the end there are 2 candidates and there is a tie. Candidate A gets 10,000 votes, candidate B gets 10,000 votes. Who is the winner? Now in this case, if either of the 2 candidates get 1 extra vote, that will make that candidate winner. Returning officer has now this power. Returning officer will mention name of A as well as B in a lot, and then randomly will pick one chit. And whichever name appears, it is as if extra vote has been cast in favor of this individual. And this individual is the winner. That is why we call him returning officer. Because you return the winner. If there is a tie, you will, through a draw of lot, pick one name, and whichever name appears, which means if A appears, this A has received an additional vote, which means now you have 1 vote more than candidate B. You are the winner. Where is it mentioned? Representation of the People Act 1951. And if you are working in Bengaluru and you are a registered voter in Bengaluru and there is a legislative assembly election in Karnataka, even if there is no holiday, for you there is a paid holiday. Because you are eligible to vote, to encourage voter participation, to encourage deepening of democracy. Paid holiday is provided to all those who are working in any business, any trade, any industrial undertaking, any establishment, if you have the right to vote. And something I don't have to tell you, you are all aware of, on the date of the election, on the day of the election, liquor is not to be sold, given or distributed on polling day. Otherwise, it will be misused as means of bribery. This is what you need to know regarding the Representation of the People Act 1951, an important law for prelims as well as the mains examination. There is one thing which I have not covered, and I will cover it later because that requires an elaborate discussion: criminalization of politics. And if you have understood this lecture, got benefited from this lecture, do let me know in the comment section, and do not forget to press the like button and subscribe to our channel if you haven't yet. Thanks for watching. Goodbye. Take care.